Good morning and welcome to the third meeting of the committee in 2020. I'd like to remind members and the public to turn off mobile phones, and any members using electronic devices to access committee papers should please ensure that they're turned to silent. Our first agenda item today is evidence on the withdrawal agreement and negotiation of the future relationship as part of the committee's Article 50 inquiry. Can I welcome the witnesses to the meeting today? They are Dr. Fabian Zulig, Chief Executive and Chief Economist at European Policy Centre, Dame Mariette Leslie, former UK diplomat and member of the First Minister's Standing Council on Europe, and Professor Anand Menon, the Professor of European Politics and Foreign Affairs at King's College London. And we're also joined by Charles Grant, Director of the Centre for European Reform, who is giving evidence today via video conference. Thank you all very much for joining us this morning. Can I start by maybe talking about the approach to the negotiations from the EU side, which I understand is guided by the treaties, in particular Article 218. Can I ask what the effect of these legal constraints is likely to be on how negotiations are likely to proceed?
The negotiations from the EU side are still taking place in the context of Article 50, but clearly now the focus is on the future relationship, and the question here is how comprehensive, how detailed the future relationship is going to be. And that then has an implication regarding the ratification of the treaty, whether it is a mixed agreement, which has a much more complicated ratification process, or whether a different agreement can cover what is necessary within this second phase of the negotiations.
And my understanding is, I think most people's understanding is that the time to negotiate is obviously extremely constrained. Do you think it's likely that an agreement will be reached within 11 months?
It certainly is a major challenge. The European Union hasn't concluded a treaty like this within 11 months. Even taking into account a lot of goodwill on both sides, which we can't guarantee, but there are a lot of technical steps which have to be gone through. In my view, it will be almost impossible to conclude. If you can conclude something, it will have to be very basic. Many of the areas which are difficult will have to be postponed into the future. And even then, there's no guarantee. If there's major conflict around any issue, there simply isn't the time to work that out. If you lose a month, a couple of months somewhere in the middle, because you can't move forward on a particular issue, then the time will not be sufficient.
Right.
To add to that, I mean, if you take one example, which is the issue of equivalence in financial services, there are sort of way over 20 areas in which equivalence has to be assessed, and the two sides have said they're going to get to an agreement by the end of June. If you think about the sort of work rate that implies for the assessors, it is very, very tight indeed. So as Fabian says, you can come to a very, very bare bones agreement by the end of the year, given political will and goodwill on both sides. But anything more than that, and if you think about the number of issues that we just haven't really discussed in sufficient depth yet, whether it's adequacy decisions on data and the implications of that for collaboration between police forces across borders and things like that. So one of the big questions going forward is that whether if they want to, both sides can find a way of maintaining something as close as possible to the status quo, which doesn't involve the Prime Minister asking for an extension formally before the end of June.
Mm-hmm. I wanted to go on to ask about how prepared each side is. Michael Barney, who is in charge of the task force going forward, has said he expects a draft mandate for the EU to be in place, a drafted negotiation mandate for the EU to be in place by the 1st of February. What about the UK? Do you think that they will have a mandate in place in the same timescales? And who's better prepared, so to speak?
Just to go, I mean, I think it's very, very hard to know on our side because the contrast between what we're doing with the European Union and what we're trying to do with the United States, Australia, New Zealand is very, very striking in the sense that DITF being relatively open in the case of all the other trade deals, but the EU negotiation is being handled by this unit from number 10, and it is largely impenetrable to the outside world. So what they are planning in the way of a negotiation remains absolutely obscure at the moment in terms of the detail.
Does anyone else have any thoughts on that particular? Yes.
If I might say, I'm sure that's right. There will have been a huge amount of work, there was a huge amount of work done inside Whitehall on the previous 2018 withdrawal agreement. People in Whitehall can dig out that work again, but what they don't have, it seems to me, at all transparently yet, is political direction from the present government under the present Prime Minister as to where they want to draw the line, because they have a range of choices on the degree of closeness to the EU they want to achieve in almost every area covered by what is a very, very long agenda. In the meantime, those same departments, in many cases, will be having to put through implementation legislation inside the UK, which is always demanding for departments and their ministers. And they will have to be following the pace of negotiations that are dynamic, not static. So whatever the British position may be will have to evolve as the negotiations continue. So it seems to me that there is an absolutely massive task for government departments, for number 10 and the Cabinet Office in coordinating it, and one that will put the existing capabilities under very, very severe strain as we go through the next few months.
Thank you. I think Charles Grant, did you want to come in there?
Could I just add to something that Anand said a moment ago? I think that a deal is possible, something that is called a deal is possible by the end of the year, so long as the UK accepts basically all the terms that the EU requires, as Anand implied. If there's going to be an argument about something and a big tiff, then there won't be an agreement by the end of the year. So that if the UK wants to kind of cave in on most of what the EU asks for in terms of level playing field provisions, there can be a deal. But I think, just to report some of my own recent conversations with people in the government in London, they do realise that they can't do everything by the end of the year, even if you could do perhaps a very simple bare bones trade deal. They know that the other deals on security, aviation, road transport, Northern Ireland border issues, and so on, research will actually take much longer. So what do you do about the transition? Well, my own conversations have led me to believe that people in London do know that there has to be an extension of the transition, but it won't be called that. Boris will be able to say, the Prime Minister actually will be able to say, we're not extending the transition, we're leaving the transition at the end of the year. But in practice, means will be found, because there'll be a desire on both sides to find the means with some legal base, and Fabian probably has better view than me as to which legal base it could be, which would allow many parts of the transition in many sectors to be extended for an additional period to ensure there isn't a cliff edge on, say, aviation at the end of next year. And so I think that the British ministers I've spoken to believe that they will need it to extend the transition, but it won't be called the transition. It'll have to be called something else.
Right. Interesting. Anand.
Very quickly, I mean, I agree with that, and I think in areas like aviation, Charles is probably right that they'll find a fix, because it's in neither side's interest for that to stop or be seriously disrupted. But I do think that on the EU side, one issue is going to be, if the British government wants the sort of trade deal that is so thin, so as the difference between the economic effect of that and the economic effect of no deal is actually fairly small, what possible incentive do they have to find ingenious legal devices within their own legal system to give us a break and extend transition without extending it? So, I mean, it needs to be worth it for them, in other words. And if we were offering something that was genuinely deep and had real economic impact, it would be more likely that they would go for it, I think, than if the government signals that actually all it wants is something that is relatively thin.
And what you think the government wants?
Well, my sense is that the government wants something relatively thin. I mean, it is remarkable after, over 3.5 years and an election that was meant to be about it, how little in terms of detail we know about what we're proposing to do.
Right. Okay, thank you very much. Donald Cameron wishes to come in as a supplementary here.
It's just on the EU's approach to the negotiations. Just two brief questions. Do you see the EU demonstrating, EU27 demonstrating a united front, as we saw in the withdrawal negotiations? And if not, where might the strains be between the various member states of the EU? And secondly, we've seen a changing of the guard in terms of EU personnel, new Commission President. Do you see that making any difference at all?
Sorry.
I think there's a difference in terms of are the EU27 going to be united in the process, and are they going to be united when it comes to different issues? In the process, I would expect that we see exactly the same kind of unitedness we have seen up to now. It is all run still through the Commission, through the task force, but many of the innovations which were introduced have been kept. So there's going to be continuous dialogue between the capitals and Brussels on this. So everything is going to be agreed on an ongoing basis. On that basis, we also have the expectation that the negotiation mandate is going to be ready very quickly, which is going to be something which is agreed between all the member states. But of course, when we are now moving into this next phase, we have a lot of different interests. So on interests, there will be differences between the member states, inevitably, particularly when we're getting into the discussion around the economic relationship. The economic relationship of every member state with Britain is different. So there will be different priorities. For some of them, for example, fisheries will be very important. Other countries have no interest in fisheries. For some of the countries, there will be certain sectors which are producing within the UK. In other countries, that's not the case. So these kind of differences will be there. I think those kind of differences actually make it more difficult to reach an agreement. If you could have argued in the first phase that any division within the 27 would have helped the UK, in the second phase, because in the end you will need all of them to agree to a trade deal, any particular issues can become roadblocks to an agreement. So every special issue a member state will bring up will have to be dealt with. For the moment, the Commission is trying to manage that process as well. It's trying to also constrain the issues which go into this negotiation. But domestic politics also exists in every single EU member state. So depending what happens in the domestic debate, different countries might bring up different issues within the negotiations. And again, within the short time we have, any such issue could then make it difficult to get to an agreement. The changing of the guards in terms of the institutions is going to make some difference. We have a different relationship between the party groups in the parliament that we shouldn't forget, because in the end the parliament will have to agree the deal, whatever deal there might be. And my reading of the parliament now is it's going to be more difficult to get agreement on contentious issues, which this might well be. The Commission, I think, will have the same broad approach as the previous Commission to these negotiations. Clearly, what matters most to the institutions in the end is making sure that the member states are happy, and as of the end of this month, the UK will no longer be a member state, so the concerns of the UK will not play a major role in whoever is going to lead the institutions thinking.
It's worth just adding the changing of the guard that key members of the Article 50 task force are now scattered in key positions across the Commission, in the cabinet of the new President of the Commission, in DG Trade. So I suspect those links between people who have run the negotiations to date will prove very important and will actually maintain a sense of continuity with what's gone before.
Thank you. Claire Baker.
Thank you, Convener. I wanted to ask about the possibility of a no deal still taking place. There was much publicised changes to the withdrawal bill as it was going through, and concerns that the agenda of the government was to achieve a no deal. Professor Menon talked about, we've now moved on to discussions around a thin deal. I suppose what you did say, it depends what's in the EU, what's in it for them. Is there a possibility that we still reach a no deal scenario, whether that's brought by the UK government or whether it's actually brought by the EU, who are unsatisfied with a fairly thin deal and subsequent years of negotiation on sectors?
On a thin deal, what I was saying was if the deal looks very thin, it is less in their interest to start to make special provision for us to find a legal fix to keep things going while we negotiate something that actually isn't that substantive. There are all sorts of ways we could end up with a no trade deal outcome. And it's worth stressing, no trade deal is different to no deal and no withdrawal agreement in terms of how disruptive. But economically, it is as severe. I mean, it's the same thing as trading with no agreement between the two sides. We could reach no deal because the two sides can't agree. We could reach no deal because they agree and there's a failure to ratify. And on ratification, I agree absolutely with what Fabien said about the European Parliament, but bear in mind, if we end up with a mixed agreement that needs approval by parliaments across Europe, what's curious about this negotiation is it's the only negotiation in history whose specific objective is to make trade more difficult. Okay? Given that, it's very hard to go home and sell victories. You're selling relatively large or small losses in terms of trade. And politically in Parliament around Europe, I can imagine that potentially being something of an issue. With people saying, well, actually, why would we sign up to this? Because actually, it might be because the difference with no deal isn't that big, or it might be that a particular Parliament wants to cause problems. So there are obviously very clear ways in which we can go to the end of the year and end up without any kind of trade deal, I think. I don't think it's the most likely outcome, but I think it is certainly possible.
And Jeff, would you like to
I
come
think I would probably agree a little bit on the probabilities. I think it's actually the most likely outcome, but I think there's this question of, in the end, do we have a broadly cooperative negotiation, or do we descend into areas where it becomes very difficult? For the moment, everyone seems to be assuming that this will work relatively cooperatively. But if we get into any real political conflict between the UK and any member state, then this whole process might well end up with no deal at all. I think in the end, given what has been put on the table by the Prime Minister, we are really talking about these two possible outcomes, either a very thin deal or no deal at all. Anything more ambitious seems very, very remote now. And just to add on the extension question, even if we wanted to continue the negotiations in some form, that would also require an agreement, and that agreement would no longer, as far as I understand, and I'm not a lawyer, but as far as I understand, that agreement would no longer be covered under Article 50. So you would have to then make a new agreement, which would be a mixed agreement, which you would then have to ratify. So even for an extension, you have to have this very difficult ratification process where you have to have every part of the European Union agreeing.
And Charles, would you like to?
Yes. On Annen's point that why should the EU agree to an extension if the trade deal is so thin as to be hardly different from no deal at all? The answer is for the other areas, surely, because if whatever happens in the trade deal, if there's a cliff edge at the end of this year, and cooperation on police cooperation, criminal cooperation and other sorts of cooperation just comes to an end immediately. That would be very bad for everybody, including EU countries. I think the EU countries would have an incentive, Annan, to find ways of extending the transition period. And I mean, Fabian's right, the legal base will be difficult. I was told yesterday by a senior member of the German Bundestag that their legal advisors say that the Vienna Convention on the law on international treaties does give you possibly quite easy ways to extend treaties if both sides to amend treaties. So I say to amend treaties if both sides agree to do it. I think if there's a will, there's a way. But Fabian's other point I think is absolutely right, that if there is a danger that if there's a very acrimonious bust up on the trade negotiations, then it's very hard to see how we can at the same time have a productive and happy outcome on the security negotiations. I don't know whether members of your committee wish to come on to the security negotiations, but that I think is one of the most important areas to consider.
So remind you, I think it's implicit in everything we've said that we're not really talking about a deal, we're talking about deals. And we're talking about probably more than one deal in the present set of negotiations, because I don't think a free trade agreement, whatever it is, will be the same in the same document as a security agreement, and both are high priorities for both sides. We're talking certainly, and it's already implicit in the political declaration, a continuing series of amendments and changes and deals in further areas and subsidiary deals well after 2020 to amend whatever may or may not have been agreed by the end of this year, and to enlarge negotiations as one goes on. And also that it seems to me crucial at a very early stage for both sides to put in place some of the things that are the enablers for everything else in every other area. So things like agreements on handling securely classified information, agreements on data protection, and so on, which need to be there to cover absolutely everything. Now, if those things aren't there, it will be very difficult to agree anything else. So the committee might like to look very closely at the Commission's negotiating mandate and how they start the negotiations probably in March, because they will have the whip hand when it comes to sequencing and how they want to address these issues in the negotiation. And that will give some clue as to where the UK has to give and when. The other thing is, I'm afraid this committee is going to be busy for some years to come, following what will be not just one negotiation.
Now, the panel as well recognised the UK government interest in trade deals with America, with Canada, I think New Zealand was mentioned. If we end up in a thin deal situation, which is largely a trade deal, so it's largely around goods, and that is reached by the end of the year, but there's still a number of other areas to be agreed, in what ways does this restrict the UK government from seeking other international deals? And does it create problems in wanting to broker other deals?
I mean, it creates a chicken and egg problem in the sense that if you're left still negotiating services or agriculture or whatever else, and so you're uncertain about the regulatory arrangements you've come to with the European Union, any other negotiating partner is going to want to know what those are, because they will have an impact on our ability to negotiate with them. So it's very, very hard to do the two simultaneously. Because the concessions we might need to get a deal with the United States might be concessions that are rendered impossible by the deal we've done with the European Union. So whilst politically it makes sense to be seen to be doing these things simultaneously, practically it's incredibly difficult because there are trade-offs involved between them.
Thank you. Thank you. Stuart McMillan, followed by Mike Rumbles.
Thank you, Convener. We've already touched upon the changing of the guard from the European Union perspective, but it's widely anticipated that the UK government will be changing government departments, and as a consequence, personnel there will clearly, new players will come into play. Do you think that this change will have an impact, but also indicate the seriousness of the UK government to actually obtain successful deals with the European Union, certainly within the 11-month time frame that we have left?
there is no such thing as a new idea in politics. So what we're effectively doing is reinventing Aegis, which was the old system by which we coordinated EU policy. And it will have an impact, yes, because this is all about prime ministerial authority over the process of negotiations with the European Union. I think the big variable, and this will determine how effective the system is going forward, is whether or not the task force in number 10 cooperates fully and openly with the new unit in the Cabinet Office, because there were complaints last time that the negotiating team didn't share information as fully as it ought to have done, which made it hard for the rest of the civil service. So actually the detailed modalities of how this works in practice will be crucial, but it will have a massive impact on how things are run going forward, I think.
The obvious point that all change is disruptive, and the time of permanent secretaries and senior officials and so on will be taken up with changing their logos and building up their teams and developing a new culture and ways of working at a time when they have a huge substantive agenda on their desks. So it is bound to add some grit into a system that is already straining. But equally, every government has the prerogative of sorting itself out the way it wants to. What we don't have a good sense of, it seems to me, any of us, is quite what the working methods and culture of this new government will be, because it is signalling that it wants to be very different from the way it was in the past. Many of its approaches towards politics have been different from things that we've been used to in parliamentary terms. I think remains to be seen whether that increases capabilities or whether it actually decreases them in the medium term. One useful thing for this committee and this parliament is that although the British government doesn't look as though it intends to be very transparent about how it sets about this, the Commission on past form will be, and so will the European Parliament. So we will be getting steady updates from the EU as to what has been negotiated as we go along with the United Kingdom.
It's worth emphasising one point about this government that will be different from its predecessor, which is, in the short term at least, and on Brexit, we have a government that will be able to agree with itself. And that, of course, was one of the fundamental constraints in the under the previous government about dealing with Brexit. But that, I think, on Brexit at least, for the short term, won't be an issue now.
Between the Trade Department, or what is left of the Trade Department after the reshuffle of the government, which will be negotiating the trade agreements with America, Australia, New Zealand, and then number 10, or the Cabinet Office, will be doing the negotiation with the EU. And I just hope there's some good coordination between the two. I mean, the biggest difficulty, I think, for Whitehall is how to get the system of priorities in place. One thing that Mrs. May wasn't really able to do was to knock heads together and put somebody in charge of a kind of star chamber process by which we say, well, we'll do, say, give this to fish and not give that to cars, or give this to farmers and not give that to the pharmaceutical industry. As of now, I'm not aware of any proper system of prioritization being worked out, but the UK needs to do that very quickly, because you can't go into a negotiation unless you know what your priorities are, and I don't think as yet that's happened.
Are there any areas where you believe that there could be some quick wins for both sides to show that there is a seriousness to obtain deals? I'm thinking examples such as like the Erasmus Plus scheme, that also this committee has undertaken work on, and also the Horizon 2020.
Yeah. I think the chances that anything is being agreed in advance before the main negotiations is very slim indeed, both in technical terms, but also in political terms. In technical terms, any kind of agreement on areas such as research, areas such as Erasmus Plus, will have to depend on the European Union agreeing on the next multi-annual financial framework first. It's impossible to negotiate with third countries around participation in programs when these programs are not defined yet. And for the moment, at least, we don't have a multi-annual financial framework agreement. Even if we have it, it will have to then be ratified, and then it has to be translated into the actual programs. The cooperation with third countries within those programs will come way down the line. We're not talking anything which, in my view, is possible even this year. We're talking way into next year. But also politically, yes, there might be an interest on particular issues, but this was what I was referring to with all the different interests coming into it. When you look at something like Horizon, the research money, there are certainly a number of countries which would have a problem with the UK having a similar position within Horizon as it has now. The UK has benefited from Horizon. I would even expect that some countries would expect that the UK will net pay into Horizon if it wants to participate. So these are actually much more difficult negotiations, which are not just going to be agreed beforehand. And in the end, what the EU is saying is we have to agree on the core issues before we even start getting into some of these discussions which are more marginal.
And bear in mind, the interests are complicated here. I mean, there are certain universities on the continent that hope that the situation of ambiguity persists because it's a way of luring people from this country to theirs with the promise of European research money. But again, fundamentally, politically, the issue for me is that notion of sequencing. I remember the political declaration says that the first two things we're going to be coming to agreements on are financial services and fisheries. And they're not easy, and it's not obvious there'll be an agreement on those. And if the European Union, as looks likely, says actually we want to get these out of the way first, then there aren't any quick wins in view.
Okay.
About fish, I think it's probably the most difficult part of the entire negotiation. I've been told by some member state governments they will not agree to any deal on anything unless the British give in on fish quite quickly. And I've heard a senior person in London, part of the government, say, we may have to give in on fish, we may have to give EU access to our waters, or we won't get anything for the City of London. So I think for the Scottish people in particular, this is really could be a very important issue, that there's a strong point of view in London that British fish can be sold to get a better deal on financial services. And I think the EU is going to be absolutely very hard on this. It's true that only about a third of the member states, or less, fewer than that, care about fish, but this is a test of solidarity. And I think even if some countries like Hungary don't have fishing fleets, or Poland doesn't have much of a fishing fleet, they will feel the need to show solidarity with those like Denmark and Belgium and France and Spain who do care about fish. So I think this could be the first and nastiest part of the entire negotiation.
Charles Grant, you said that this information was given to you by a senior person in London. Was this quite recently?
It was within the last week. I mean, to be fair, he didn't say we will sell Scottish fish to buy Financial Services Act. It wasn't that brutal. He just said the kind of thing we may well have to do is to give access to EU boats in our waters. Otherwise, we won't be able to get anything on financial services. He was implying to me that he thought that such a trade-off or bargain, which has in fact been suggested by Phil Hogan, the EU's Trade Commissioner, was at least something to be seriously considered and quite plausible.
And this was a member of the negotiating team or a member of the government?
A senior official in the government. I won't say more than that.
Okay, thank you very much. Fabian, you're indicating you wish to come in.
I just wanted to pick that up because I think it highlights a very important point in these negotiations. That we are now moving into at least some form of trade negotiations. So what is important is to actually find out what is the UK's offer. What are the areas where the UK is willing to concede, is willing to accept EU demands in return for what else? And as long as the UK is not clear about what that offer is, these negotiations are not going to go anywhere. For the EU to have something to negotiate with, there has to be a clear understanding of what the priorities are and what the UK is willing to give up.
Thank you. Mariette.
And the UK has long entertained the hope that it has an offer that the EU would find irresistible on security, and that will be its trump card. That's why the sequencing questions are so important. If the EU says, we hear you, we see your security, but we're going to deal with fish before we discuss that, then if I were an EU negotiator, I think that's what I would do. And I don't think the UK will have a lot of leverage on the sequencing issues that will allow it to play that security card early in a way it might wish to. Security, incidentally, isn't simple for either the EU or the UK. There is a clear mutual interest in having a really good, deep relationship in that area. But there are also, inevitably, when you come to the defence industries on both sides, some very difficult issues of competition, of national interests, of links back to the trade negotiations, links to some of the service issues, and links to the data protection issues. And so I think it will be a very much more difficult negotiation that, if there were very good will from the start, could have been dealt with in the course of the year because the mutual interests are very high, but the technical interests are also so high that I can't see it being dealt with adequately in the 11 months we have left, particularly since it's one that will require ratification by member states.
But you think trading fish for financial services is something that will be more easy to achieve?
A bagatelle compared with some of the defence interests. No, I think it. No, I'm being unfairly facetious. No, it will be very difficult.
I just think it's worth saying that, you know, one interesting question around these talks is whether it is possible practically to be very close security partners if you're turning into intense economic competitors. And there are obvious areas of crossover there, like Galileo, where there are very, very big commercial interests at stake, and it might be in the interest of some member states to say the UK can't be in. But having a competitive economic and a collaborative security relationship is going to be very hard and extremely hard to negotiate around, I think, in defence industry areas and others.
Okay, thank you. Fabian.
Just to add, I think one of the parties in this negotiation, if you like, we shouldn't forget, is the European Court of Justice. Many of these areas touch competences of the European Union. If we're talking about a number of the assessments which need to make, these are unilateral assessments by the Commission, but they are also open to judicial review. So we might well end up in front of the court on a number of these issues. For example, on equivalence questions, whether the European Court will accept this is an open question. So this again adds to the complexity of the negotiations, that even if there's a goodwill, some things might just legally not possible.
Okay, thank you very much. Mike Rumbles.
Thanks, Convener, and good morning, panel. I'm also a member of our Rural Economy Committee, as well as this committee, and I am very interested to hear your responses to the question on fisheries. I want to just park that, but I want to focus really on the issue and the impact on Scottish agriculture. The Commission President has said that we're ready to design the new partnership with zero tariffs and zero quotas, and considering that 40% of Scottish food and drink exports are traded with the EU, 88% of Scottish beef and 95% of Scottish sheep meat exports are with the EU. It's going to be incredibly important from Scotland's rural economy to get an agreement with this by the end of the year. So, two parts of the question. How realistic do you think that is going to get that agreement? And what are the implications if we don't get it?
The thing I would say is, I suspect what the European Union said or meant was you can have zero tariffs and zero quotas, but there are a whole host of our regulations that you need to sign up to as well. And in fact, even if they didn't say that, to keep trade moving as frictionlessly as it does now, it's not enough just to have no tariffs and rules. You need to have agreement on the rules.
Have the regulations now, they are the same, aren't they?
Yeah, but that's not what concerns the European Union. What concerns the European Union is not where we start, it's where we intend to end up. It's not enough for us to say we are the same now. I mean, it is quite clear that the government wants to have the right to diverge. And if you want to have the right to diverge, that raises all sorts of alarm bells. You immediately start being treated as if you've fully diverged if you can't find a system for agreeing that you haven't. That's the key thing. Mm-hmm. And so a lot there is going to hinge on whether or not the government in a sector like agriculture, about which we've heard not that much as yet, is willing to say, okay, whilst on cars or financial services we want regulatory autonomy because the Bank of England doesn't want us to be under EU rules for financial services. Under agriculture, we might make an exception. But I've heard nothing as yet that would indicate that kind of flexibility.
Hasn't the UK government said that we won't reduce standards in agriculture because of that issue?
But again, this boils down to a question of trust. It relies on the other side trusting you to maintain that, and that's not how the European Union works. The European Union will say, okay, that's fair enough. We need to have some oversight mechanism, and it might be that they come up with an extremely clever oversight mechanism that works for the European Union that isn't the European Court of Justice, though I'm yet to be convinced that is possible. But unless we do that, the European Union is likely to say, no, we assume divergence unless we can get that process in place. I mean, that's the fundamental lie to the claim that we're starting in the same place, so it will be easy. If you ask anyone in Brussels, they'll say, but the government has spent the last 3 years talking about divergence and regulatory autonomy, so it's where you're headed to, and what guarantees do we have about the future?
Maybe to add to that, the moment the transition ends, from an EU perspective, the regime is less safe than it was before, because what you have up until the end of transition is a common enforcement mechanism, you have a common governance, and in the end, you have the European Court of Justice. So whatever a country within the European Union might or might not want to do, there is a common governance which enforces the common rules. The moment the UK is outside of that mechanism, it is by definition not as reliable as being inside the European Union. So there have to be, for all those areas where there has to be enforcement, there have to be mechanisms found, there has to be a governance found, which reassures the European legal system that what is happening on the UK side is also in practice in terms of what the courts actually hand down at the same standard, at the same level as within the European Union. On top of that, and I think this is something where we cannot foresee yet what is going to happen, but there is no guarantee that individual country interests are not going to come into this. And when it comes to agriculture, agriculture is the probably biggest sticking point in international trade negotiations. It is always the most difficult one. It is also the one where the relationship both of the EU and of the UK with third countries is going to be important. What happens, for example, when the EU concludes a trade deal with New Zealand? You were mentioning lamb. That is one of the issues which clearly New Zealand will expect to be covered within the trade deal between the EU and New Zealand. So the question then is, what implications does that have for the trade between the UK and the EU?
Can I just follow you up on that? Because,
Sure.
because New Zealand, if they have the trade deal with the EU, will not be subject to rules from the European Court. So, and they won't be setting up, will they, another mechanism for enforcement? Surely a trade deal between the EU and a third party is not reliant on setting up another body for regulation. I mean, if New Zealand doesn't abide by its agreement with the EU, the answer is very simple. You stop that agreement. Same way with the UK, surely. If we don't abide by an agreement that is reached, that agreement ends. Well, you don't need another mechanism, surely.
From a very, very different position. It's worth bearing that in mind. At the moment, we trade in agriculture with the European Union as if we were trading inside the same country. And that is not how New Zealand will trade with the European Union, even if it gets a trade deal. So what we're saying is, from the status quo where we are now, that would not be the same, because it would be, there would be more friction in that trading relationship than if we were inside or had agreed to sign up to the same rules. So it's just a qualitatively different sort of trading relationship.
This will come as news to our farmers because... Sorry?
So when New Zealand land enters the EU, it has to go, I believe it has to go through physical inspection points, and the EU's rules on physically inspecting all incoming farm and animal produce are very strict. Now, the one country that's been exempted of such rules, I believe, is Switzerland. But Switzerland is exempted from these physical inspections because the Swiss have signed up to basically the entire EU rule book on plant and animal health, and have agreed, I believe, to sort of to update their rules when they need to update the rules. So that the best kind of deal for British farmers would be some sort of Swiss-type deal. But can the government agree to follow all the EU's rules on plant animal health? That'll be very difficult politically for the government. If not, there will be physical inspections on Scottish lamb exports going into the EU post-Brexit.
The question is also what the economic interests of farmers in the EU are going to be. If you are importing, for example, lamb from New Zealand, that might be traded off against other areas within the negotiations, and you might not have an interest in allowing the same kind of access for lamb from the UK, which is, after all, a third country. So normally in agriculture, every trading bloc, including the EU, has restrictions on this. It's not open trade. There are quotas, there are tariffs even after a trade deal. It is an area which is littered with exemptions when you look at international trade. So this is not an area where the presumption of free and open trade normally applies. That's much more common in goods than it is in agriculture. In agriculture, it's far more limited. So if the UK wants to have something which is close to the current status quo, that requires a lot more than just simply saying we don't want any tariffs or quotas.
I think it's also worth remembering that what Michel Barnier actually said, and he said it more than once, was zero tariffs, zero quotas, zero dumping. And it's that zero dumping, this is diplomat speak, it takes one to know one. You take it as a package, and you can only get the zero tariffs and the zero quotas if you go for the zero dumping, which means, as others on the panel have said, you take on our rule book, because we would be inclined to regard any animal health or phytosanitary or other things that don't meet our regulatory requirements as amounting to an attempt to undercut competition and therefore dump.
But
and that's where the dilemma lies for the British government and therefore for Scottish farmers, because if you take the EU rule book, you have a great deal of trouble doing a trade deal on agriculture with the US, which will have agriculture very high up its priorities. If you take the US rule book and the types of phytosanitary and other arrangements that the US would like to have, then the EU will regard us as being in the dumping category, and that will make it very difficult to do the tariffs and quotas deals on agriculture with the EU.
Our farming organisations in Scotland anyway, and I can't speak for the UK, but certainly Scottish NFU and others are taking the view that it shouldn't be a problem because Scottish farmers want to keep the high standards of EU regulation and animal and plant health. So if the industry in Scotland wants to do that, and the government has said that's what it wants to do as well, I can't see what the real problem is going to be if everybody agrees that that's what they want to do.
Will be that unless there are auditable arrangements for checking that inside the UK, that the EU can inspect and agree meet those standards, then the EU will insist on having regulatory checks at the border. And it doesn't look as though the UK government wants to have anything like that apparatus in place inside the United Kingdom, partly because of its wish to do agricultural trade deals with other countries. So that is the horns of the dilemma. And whatever extremely high standards Scottish farmers may meet, and I know they do, that won't help if their sovereign state, the UK, has in place a regulatory framework that doesn't meet the regulatory requirements of other countries' trade deals.
Okay, thank you very much, Ross Graham.
Thank you, Convener. I'd like to go back to the issues around sequencing and timetable, and particularly what Claire Baker brought up. The UK government's line is still that trade negotiations with the EU and with the US will be conducted in parallel this year. Their intention still to publish both sets of objectives at the same time next month. And the Chancellor of Davos for the last couple of days was sticking to that line until the end of his contribution on a panel where he was sitting alongside the US Treasury Secretary, where he said, but we want to get the EU deal done first. Is this a growing recognition, or do you believe this is a growing recognition of reality within the UK government, or is there still an intention to try and run these as if they are two similar and parallel sets of negotiations?
We don't know whether he misspoke. I mean, the reaction from the US side was interesting to his comment as well. The British government finds itself caught in a very, very hard place here. I am sure, well, I know, I mean, if you just look at the forecast that the government has done, the economically more important relationship is the relationship with the European Union. Whether or not that transfers into the politics is far from clear. I mean, you know, this is a story of the triumph of politics over economics, this whole saga, and that doesn't show any signs of stopping, to be honest.
The US deal that, sorry, the objectives of the US side in the negotiation have been kind of described at length from a variety of sources. The UK negotiations are still unclear, but you mentioned earlier on, given the timescales that are required, any deal that could be done with the EU before the end of this year, you described it as it would be a relatively thin deal. The US intentions are for a deal to be agreed before their presidential election in November. Now, accepting that that is vanishingly unlikely, if it were to come about, presumably it would also be an incredibly thin deal. What would a very thin US, a bare bones US-UK trade deal actually look like? What are the few areas that could conceivably be agreed before November?
The quickest area is tariffs, and it's quick for two reasons, I suppose. One, because tariffs between us and the US are pretty low across the board, apart from some areas. We did a study about 2.5 years ago, and we modelled what would happen in the event that the UK and the US scrapped every single tariff on trade between the two sides, and the net benefit to the UK economy was about 0.3% of GDP. So there's relatively little in the way of gains there, but it's easy because tariffs are quite low. But also, it's a lot easier than doing the hard stuff, which is services, which means coming to some sort of agreement on regulations. And there, the prospects of getting some kind of deal strike me as being vanishingly slim.
And, yeah.
Just to say, I'm also from the experience of the EU with the US. I would find it incredibly strange if the US doesn't put agriculture on the table. And clearly that opens a number of different issues. I cannot see that with agriculture involved you could come to any kind of meaningful deal, even if the UK was willing to make some of the compromises which would be entailed by that. So I think this is more of a political statement than the reality. For a real trade deal, you would also have to look at ratification in the US. It is Congress, it is not the President, which would have the decisive role there. And that in the middle of a presidential election campaign where all of these things become political balls. I don't see anything meaningful, so there might be some form of announcement to try to create the impression that there is progress, but in reality there is nothing which can be agreed by the end of this year.
And Charles mentioned the need for quite a high-level coordination, given it's not just separate teams, but separate departments, Team Inside Number 10 that Annan mentioned, and DIT running the US negotiations. Is that anything like normal for how a country would conduct trade negotiations? To have obviously separate teams, but to have separate departments of governments leading on negotiations that are still, at this level of objective, that are still described as being comprehensive. They still want something comprehensive. Do countries typically have different departments leading on comprehensive negotiations?
I think it depends. It's difficult to say for the European Union because the European Union has conducted its trade negotiations through the Commission as the competences lie with the European Union. But I think it is clearly when you have international negotiations, you need a person who is conducting those. So every country has some form of trade representative in these negotiations. but that doesn't reduce the need for coordinating the domestic position. And I would say actually the challenge is much greater than simply coordinating between departments. To have a trade deal which works in the end, which is acceptable, you need to have much broader involvement. You need to have, in some countries certainly, you need to also have the involvement of other sub-state actors. You have a whole host of different interests, from business to NGOs to civil society, which also have to be involved in these negotiations, because experience shows us in the European Union that if you negotiate something without having that kind of agreement, there's no public acceptance, and then ratification become a real issue. So this is something where I think the European Union over the last years has learned a lot about how to conduct these kind of negotiations. It is much more open, much more involving of all these other actors, but it's something the UK will also have to look at. So it's an enormous coordination issue.
Can I say a couple of things? I mean, firstly, if you talk to business groups, what they'll say is they get pretty good access to DIT for discussions and consultations around all of the trade deals, New Zealand, Australia, United States, but none when it comes to the EU one, which is being handled differently. So there's that contrast. And I mean, the paradox at the heart of this is the institutional structure we have in place speaks to the primacy of the EU negotiations, because that's being led by number 10. The politics doesn't accept that primacy. So there's a slight tension between what the politicians are saying and the nature of the structures they've put in place.
Thanks. One final question, Convener, if there's time. Yeah. There have been reports in the last couple of days that the EU is not prepared to offer the UK conformity assessments. If you dig into those reports, they're not prepared to offer conformity assessments unless it is a full level playing field agreement. I was wondering if you could elaborate a little on what would be motivating that relatively hard line in negotiations, if indeed that is the case, if you believe those reports are likely to be true.
I mean, I think for the moment at least, I would take all of these reports with a pinch of salt. These are positions which are being developed. It's also a question of what is going to be agreed with the member states, what kind of positions the EU will take on certain areas. Yes, there's still some scope. Where I would say politically, certainly, there's very little scope, is that the European Union will accept any kind of trade deal with the UK unless the UK signs up to level playing field conditions. That is a minimum requirement. It has a very, very high priority in a number of important capitals. So in many ways, I would put it similar to the fisheries question. Unless the UK concedes on this right at the beginning of these negotiations, there is no scope in reaching a trade deal by the end of the year.
Thank you.
Thank you. Alexandra.
Thank you, Convener. You've talked about and identified with us that the timescales are very tight on most and all areas over the process. But can I look at the movement and mobility framework that may well be being discussed? And how important do you think that immigration will be discussed over the next 11 months into how that progresses? And also, if that is the case, what will be the EU looking for in some of that negotiations when it comes to the mobility and movement? Because we will have, short-term visits or business or leisure or that nature. But when it comes to the other side, what do you think they will actually be looking for?
I think it's important to look at the different aspects to this. There is the agreement with the withdrawal agreement on how the question of EU citizens who are in the UK or who are going to come to the UK during the transition period is handled. So in a sense, this is simply an implementation question from an EU perspective. Then there's the question of movement when we look at Ireland, Northern Ireland, the Common Travel Area, where clearly we have the implementation of the protocol, and there will be discussion around that at that point as well. I think when it comes to movement of UK citizens to the EU, EU citizens to the UK, if these are permanent, then they will be governed by national immigration laws. There will not be a European dimension to this. When it comes to business, I think this is one of the big unanswered questions, because free movement of people for the purpose of conducting business then gets into services trade. So the question is whether there will be some form of arrangement, but it has to be said that also within the EU, arrangements have been tightened up for that. So if you are traveling within the EU for the purposes of providing a service, there are now certain procedures you should be following in terms of registering with social security authorities, etc. So if we get into that area, it becomes much more difficult, but the presumption from my part would be that this simply will be wrapped up in the negotiations around services, which will not take place this year.
Anand, do you want to?
Well, I was going to say, I see little, if any, prospect of anything being done on this in the negotiations this year. In fact, I see little, if any, prospect of this country having its new system in place and working by the start of next year. So, I mean, there's an awful lot to do here to ensure not just the system. As Fabian says, there are two different issues here. We are struggling to get the system for EU citizens who are already here sorted and working well. Then we have to get a system in place to deal with those who arrive after that date, the new points-based system. That's not going to be in place and working properly by the start of next year. But I don't think we'll start negotiating in the trade deal anything on mobility with the European Union.
So all of that you anticipate will have to be kicked further down the road, and there'll have to be renegotiation or a timescale much later than is being proposed at present.
Yeah, if it figures in the negotiations at all and both sides don't just put in place their own systems. I mean, the European Union, I think, and Fabian can correct me if I'm wrong, it's either a question of free movement in their deals with, say, the EFTA countries or with Switzerland. But apart from that, I don't think there's and Ukraine to a certain extent. But in general, EU trade deals don't touch on movement of people, do they?
Not substantively,
no. It seems to me, from the point of view of your constituents who have an interest in this, there are really perhaps three very obvious points where it bites. First, on just travel for people going on holiday. This year, there won't be any difference. Next year, hard baked into it is a change in status, a change in ability to travel freely. If it happens the way both sides want, for short-term holiday visits, there will be no change. There'll be, in effect, visa-free travel, possibly with having UK citizens having to get a Schengen pass that will last them a considerable length of time. But there will be a cliff edge at the end of December if, and I'm sure it's correct, the service issues to do with mobility are not negotiated this year. There'll be a cliff edge for recognition of professional qualifications, which could well affect some of your constituents. There'll be a cliff edge for establishment and a cliff edge for being able to offer services across borders and travel to and fro freely. And without something in place, individuals will have to fall back on the national third country rules of whichever country it is they're dealing with, and that might be 27 different rules.
Yeah. And as you identified, they may all be different rules depending on which country you're actually supporting and being involved with.
Even if you're a tourist, bear in mind your rights to access certain basic services like healthcare or your right to take your pet will be fundamentally different once transition has ended.
Okay. Thank you.
Okay, thank you very much. Annabel Ewing.
Thank you. Good morning. Picking up on a few issues raised thus far. We talked about fish. It was very interesting what Charles Grant said. He was able to bring some interesting information to the table this morning, because obviously there are some of us around this table who have suspected that this, of course, would be the case, that Scotland's fishing industry would be once again traded away. Indeed, I was just looking at a comment that was made by the 1973 UK Tory government, where they said, and I quote directly, "In light of Britain's wider European interests, they, the Scottish fishermen, are expendable." Some 47 years later, we seem to be, sadly, in exactly the same position. And taking that as a negotiating imperative, which clearly it is, and taking into account the fact that the UK has locked itself into 31 December 2020, I was really interested in Charles Grant's comment about how they will try to dress up not asking for an extension. But actually, as far as the EU is concerned, how will that work? Because we've just talked about various issues of cliff edge, which can't be dressed up just by some piece of paper unless it is meaningful for those individuals, that they can take their pet, for example, abroad, they can travel without undue restriction. So what is to give here in terms of the July date trigger for asking for more? I just am not really following this. You can dress things up and you can spin, but if people's reality is absolutely the obverse of that, the converse of that, then how do you dress that up? Does anybody have any comments? Charles, maybe you want to kick off. You brought up the subject. So.
I think there's not much chance of the end of June extension contained in the withdrawal agreement being activated by the British government and the EU, because Boris Johnson has said he won't do it and he's legislated to prevent himself from doing it. And I think he'd get into serious political trouble with his own party if he reneged on that promise, whatever the pressure from business, which is quite enormous for him to do so. So I don't think that's on the cards. What I think is on the cards, as I said earlier, is if in the autumn it's clear that it will become clear to everybody that in practice we need de facto extension in many areas of the relationship, then the hunt will be on to find a legal mechanism to do that that's relatively painless. And if there's goodwill on all sides, it'll happen. But the lawyers will find the right way of doing it. Of course, if there's ill will, then it may not happen. But if there's goodwill, it will happen. And I think it won't be called a transition period or an implementation period, but it'll be called something. It'll be effectively covering many of the areas of cooperation in, for example, police cooperation. For perhaps some of the, Marriott mentioned mutual recognition of professional qualifications, but some of these areas where both sides would suffer from a sudden abrupt cliff edge, then there'll be a desire to extend it. Now, there's a difficulty, of course, of payment, because the EU is not going to give the British a free transition without the British paying for it, even if it's not called a transition. And that'll be very, very difficult. And I think and the Court of Justice, of course, the EU will insist the Court of Justice plays a role in any quasi-transition that both sides agree on. But UK will have to be a rule taker. So it'll be very uncomfortable for the UK. So the question is, can both sides disguise this extended transition so it doesn't look too unpleasant, doesn't look too painful, doesn't look too expensive? Can they find ways of massaging the reality so that it doesn't look as bad as it really is?
That have been mentioned already. Firstly is legal basis. Under what legal basis the European Union can do this remains to me very, very unclear, and there's a debate about this amongst lawyers. And secondly, as Fabian said earlier, ratification. If you need an agreement to extend without extending, as it were, that will have to be ratified, and that won't necessarily be straightforward.
I think it's important, maybe we should not use the term extension of transition, because it will not be an extension of transition. It cannot be an extension of transition unless it is agreed before June, because there's not a legal basis for extending transition. Transition is only there because of the agreement under Article 50. You can have a new agreement. You can get to a new legal base, but that requires actually agreeing on something. And then you are in a situation where in many ways you're trying to preempt an agreement. You're trying to get all of the member states, because then you have a mixed agreement, which means you have ratification in all of the member states. In some places, as we know, you will also get Flanders and Wallonia and some of those places which will have to agree. And they have to agree to a substantive new deal. It's not just simply a technical deal, it is a substantive new deal. On top of that, we also have to see how far that is compatible with international obligations, in particular under WTO. If we are offering preferential access to the UK, under most favored nation, there are a number of countries which might well try to then use that as the legal basis for making their access to the EU more favorable. And certainly the EU is not going to allow all of the third countries with which the EU has a trade deal to come in on favorable terms, as you will have in the transition. So I think the technical difficulties, particularly when it comes to trade issues, maybe on some of the other issues you can make mini deals where that is within the competence of the European Union. But on some of the big issues like trade deals, I fail to see how this would be practically possible and how you would actually get the legal basis in place. And then get it all ratified by all of the member states in time for the end of the year.
It's perhaps worth remembering, and Fabian might like to comment because he knows more than I do, that when last faced with a potential no-deal cliff edge, the EU side took unilateral measures to crisis management contingency plans to mitigate the effects in some areas like aviation temporarily. That would be open to them again in the limited number of areas where they thought it was essential to stop chaos. And I guess they would, if necessary, take the risk of challenges from other countries in the WTO and simply say this was a temporary time-limited emergency measure to stop planes falling out of the air or facilitate
We can ask
them,
what would temporary time-limited, what would that look like? Temporary time.
It would look very like the measures that they took and announced
Just over what period
18
of
months
time?
ago.
Sorry to interrupt, but what period of time are we talking about?
Well, they were all there.
Varied. The common feature amongst all of them was the European Union reserved the right to withdraw any or all of them at its time of choosing.
And they were essentially unilateral measures by the EU, so they didn't. The focus was on those areas where the EU could take certain actions, allow certain things, where it was strictly also in the EU interest. I mean, this was clearly about making sure that wherever possible you could mitigate against the negative effect on EU citizens. But there are very, very severe limits to that. And I think, coming back to the point, many of these things will end up in front of the European Court of Justice. And there we have a different situation, because if the European Court of Justice strikes anything down, then it cannot stand. That is the rule of law within the European Union. And I think there are many areas where at the moment people are making assumptions about what might be acceptable to the court, where I think when it comes to actually testing that in front of the court, I would be far less confident that the court will simply go along with these kind of assumptions. The court is independent, the court is responsible for upholding the treaties, and the court will do that no matter how inconvenient that might be for the member states.
I just found a reference to Article 39 of the Vienna Convention on the Law of Treaties, and I was told last night that the legal service of the German Bundestag is pointing members of the Bundestag to Article 39, which basically says the treaty may be amended by agreement between both parties. And according to these lawyers in the Bundestag, apparently, and this is second-hand, I got it from a member of the Bundestag last night, they think that you can extend de facto parts of the transition quite easily through using the Article 39 of the Vienna Convention. But I'm sure, as Fabian says, it would be extremely complicated in practice. But I think if there's generally, as far as EU lawyers are concerned, if there's a will, there's a way.
Yes, I would think the President has shown that out. That's a very interesting reference there. But obviously, it's the political will, and that remains to be seen. Turning to, in that regard, absolutely, to the issue of financial services, which obviously for the UK government is a very important sector. What are the chances of, I think Professor Mennell referred to equivalence in about 20 areas. What are the chances, by July, what are the chances of that, not least because the UK Chancellor has come out this week to say in general, broad brush terms, there's not going to be any alignment. That's not going to be the UK government's negotiating approach, so across the board. So how do those two things reconcile with each other?
Well, equivalence is slightly different to the sort of mutual recognition. So in that sense, it is simply the EU authorities saying the regulatory system in place is basically in accordance. We find it satisfactory, but the rub to that, and this is why even if we got all the equivalence decisions, uncertainty would persist, is that the European Union, under its normal equivalence procedures, reserves the right at 30 days' notice to withdraw approval. So you're always then slightly uncertain, and it limits, the government has the freedom to change the regulations around financial services, but the EU has the freedom then to say, actually, you're no longer certified as equivalent. So there's that, it's a slightly different sort of relationship to the one we were talking about with agriculture earlier when we were talking about joint enforcement, but it makes for great sort of uncertainty if and when the British government decides to change its rules.
Okay. I mean, certainly the two things are not the same, but nonetheless, it's a kind of expresses a general desire on the part of the UK or not to be a good, citizen and to be negotiating in a reasonable manner. And on financial services, I mean, the EU, has a whole body of regulations in financial services, and many of those will be subject to updating as the financial products change and all the rest of it. So given the need, particularly for certainty in financial operations, legal certainty, how does this all work then if the UK decides not suddenly to implement, a supplement to the Investment Services Directive, and then the EU takes its position after a certain point in time? What about the financial certainty and the legal certainty of all these financial transactions that are occurring on the basis of this sort of non-legal legal regime? What happens there?
And under equivalence, it's not a question of doing what Charles was saying the Swiss have to do, which is updating our law if the EU changes its law. It is simply complying with the adequacy. It's simply persuading the European Union that the way we do things is compatible with the way they do things. So it's not quite as stringent as...
But with respect, there are very detailed rules on the financial services passport for banks, investment services, UCITS, insurance industry and so on. The very detailed rules on capital adequacy, detailed rules on large exposures, detailed rules on the manner of conduct of services and all the rest of it. So, unless the UK is signing up to that, then, host member states are going, when their own financial institutions are having to comply with this plethora of, quite strict regulatory enforcement, at a certain point, something's got to give if they feel that the UK are coming in on the dumping approach that Dame Leslie referred to.
At which point,
something has to give at that point.
At which point they'll turn around and say, with 30 days' notice...
Well, yeah, but, that's not really the way the financial industry works. 30 days' notice to...
No, absolutely.
Well, the way the financial industry works is people will take their brass plate and put it in a UK member state and have two branches and a holding structure.
I would distinguish between... Sorry, can I just butt in there? That I would distinguish between the impact of all this on the City of London and the impact of all, and possibly Edinburgh, and the impact of all this on the financial firms themselves. The financial firms are not going to be badly damaged. They've made preparations. They've opened the brass plates already in many continental cities. They've had to move some people there already. They will gradually move more in future years as EU regulators force them to do so. Most of the banks and fund management firms I talk to are relatively relaxed about a hard Brexit. They've made their preparations and they won't be hurt. The problem is that the city may be hurt, and indeed Edinburgh may be hurt. I don't know much about Edinburgh, I admit, in the financial service industry there, because there will be a migration of capital, management and staff from British financial centres into EU centres, gradually, small at first, building up over the years. But the firms themselves think they won't be too badly hurt. They just got the cost of relocation. It's a bit of a bother, but not much worse than that.
Yes, I mean, I do understand that many larger financial institutions have already taken the measures that they deem necessary. Although there are rules, you can't just kind of shop your headquarters. You actually have to have a meaningful base there, otherwise you don't get the home passport. But last question would be, for services in general, I mean, are we looking at years and years to get a comprehensive services deal in place?
A services deal, as long as we have a British government that wants the right to diverge. Because that's why services are so tricky. They're deeply intrusive because they require you to coordinate your domestic regulation in a way that simply scrapping tariffs doesn't. So I'm not sure that the British government isn't talking in terms of a comprehensive deal on services.
Also be recognized that if you look globally, the only comprehensive deal on services we have is the single market. Services don't feature very much in trade deals. There's a chapter, but when you look at it overall, it is rather minimal and in some ways pretty meaningless.
Perhaps I could just rephrase that. Sorry, I meant a comprehensive deal, you know, a comprehensive series of mini deals. I meant that the totality of the services sector, be it by one deal or many mini deals, but that the totality of the area of services is covered. When do we expect to see that? What's your prediction? Your crystal ball? Never.
Yeah. I mean, I think it is very unlikely because also when you get into services, many different horizontal issues are involved in that as well. You have to, for example, have a comprehensive agreement on data protection. You have to have something on mobility of people supplying services. You get into areas of qualifications. It is so difficult. I mean, this is why when we are looking at the single market, services have been extremely tricky within the framework of the single market. So to have something which comes anywhere near that, I think that expectation I wouldn't have from these trade negotiations.
I point you towards the Royal Institute of British Architects, who've done some interesting work on what a services agreement means for them across Europe. But I also just underline the fact that one of the problems is the line between goods and services isn't wholly clear. So if you think about a manufacturer like Rolls-Royce, a large volume of their sales is services. It is service packages for the goods they sell and things like that. So it's not simply a question of law firms being hit by this. Many manufacturers are very, very leery about the absence of provisions for services because it will hit them quite badly as well.
No, I absolutely take that point. Maybe last word from Brussels, Mr. Grant. What's your prediction? And
I would agree with you that the services deal isn't going to happen. And Fabian's absolutely right. The only serious services deal ever made is the single market, because even that is very imperfect. There are many service industries where there is no effective single market. So I think he's absolutely right. I don't see the UK agreeing to free movement, which means that the EU will not agree to any significant deal on services.
Thank you.
Thank you very much. Kenneth.
Very much, Convener. Good morning, panel. I'm interested in exploring how the European Union's attitude and approach to Scotland is evolving at this time. I mean, Scotland has shown itself to be open to European institutions, welcoming to European citizens. The country voted overwhelmingly for Remain, as you know. So I'm just wondering, both in the current devolved context and if Scotland should move forward to independence, how it is being perceived and is likely to be perceived by European nations and the European Union itself.
I think we have to distinguish between the case of the current status quo. If nothing changes constitutionally for Scotland, then I'm afraid that the goodwill which is there is not going to make much of a material difference. Scotland will leave together with the rest of the UK, and it will not have a particular role within the negotiations unless the UK government chooses to emphasize particular issues of importance to Scotland. That, I think, ultimately, however fair that might be, the UK leaves the European Union and Scotland is part of that. When it comes to the question of independence, then I think that is a different debate. I would not expect that the European Union will engage in that debate unless it becomes more concrete than it is at the moment. I think, yes, there are some sympathies for the position Scotland finds itself in, but there are also practical questions which would be raised by this. But that is something I wouldn't expect the European Union to engage with unless it becomes a real possibility.
Okay. The one thing I would say on this is I would be wary of expecting the same kind of flexibility from the European Union for Scotland as they've shown towards Northern Ireland. I mean, some people sort of draw the analogy saying, well, look, they've made these sort of special provisions for Northern Ireland, they've watered down the sort of indivisibility of the free market, there's a degree of ambiguity around the Northern Ireland deal. There are specific reasons for that, not least the EU's role in the Good Friday Agreement and the fact that the vital interests of an existing member state were engaged in the case of Northern Ireland. So I wouldn't assume that the level of flexibility apparent over Northern Ireland will be apparent for Scotland in the future.
Okay, so Scotland is being effectively excluded from current negotiations, as you know, certainly the devolved government here is. So how can the Scottish Government deepen its relationship with Europe? Because the Scottish Government, I mean, there is an element of frustration because we are pro-European and we do want to engage more fully with Europe. How can we do that in the current context?
I think we have to acknowledge in Scotland that a lot of goodwill was generated in European Parliament and European capitals by the very vocal pro-Europeanness of Scotland in the context of the Brexit debate and the referendum. But that visibility of that is going to evaporate as member states move on to the next stage, which is negotiating the future arrangements. And we will no longer have members of the Scottish members of the European Parliament making the case there inside the EP. The Scottish Government will continue, I'm sure, to engage as much as it possibly can, not only with European governments, but with other European institutions, civil society, universities, researchers, and so on. And a lot of Scottish civic organisations will continue to do that and ought to be encouraged to do that. It will be absolutely vital. But I'm afraid I think Fabian is correct that Scotland will not have much purchase on this under the current arrangements. It seems to me that Scotland ought to be thinking hard about the areas where there might be European institutions, most of them inside the EU, but some of them elsewhere, sort of alongside the EU rather than part of its institutional structure, where Scottish professional bodies, this Parliament in its relations with the European Parliament, for instance, would want to proactively pursue contacts, because otherwise they will simply wither because the other side won't have any visibility of them. Within the political declaration, there is a paragraph towards the end on structures that talks about both parties encouraging contacts and dialogue between the European Parliament and the Westminster Parliament. There's no mention of the devolved parliaments in that. But actually, given that the future arrangement will involve matters that are devolved to this Parliament and the Scottish Government, and that's also true of Wales and Northern Ireland, it seems to me at least worth considering how the Parliament, this Parliament, is going to pursue relations with the European Parliament and what structures might be in place there. Obviously, go on making the case for a Scottish interest in Horizon Europe, in Erasmus, in all the other programmes. You have to go on making that noise because it may not be heard and acted on immediately, but water dropping on stone, it continues to have an effect. Universities will continue to have contacts. But there is no doubt at all that under the current constitutional arrangements, Scotland will become very, very much less visible and have less leverage in Europe, and the leverage via the UK institutions at present looks limited as a matter of political will.
So in reality, Scotland's likely to become increasingly marginalised within Europe, probably less than, for example, a German Länder of a lot less influence than that. So, I mean, if Scotland does move forward to independence, I mean, I appreciate the European Union won't want to comment directly, but I would take it that providing there's a constitutionally agreed referendum between Scotland and the UK, then hostility towards that would be much less than, for example, it was perceived to be in some quarters in 2014. Would that be right?
I think two things have changed since... Sorry.
So I was just going to say that I think the key thing for the EU on this will actually be the question of legality. The reason why the EU has not taken Catalonia's side in the last couple of years is because the Catalans are pursuing a course of action which the EU perceives as illegal. But so long as Scotland moves towards independence according to the Constitution and in cooperation with Westminster, as you said, with another referendum that both sides agree on, I think the EU would look very benignly on Scottish independence. And the Spanish, as you're aware, have rather shifted their line in the last 5 years or so from being totally hostile to the idea of Scottish independence to not necessarily hostile. So I think as long as Scotland pursues a law-abiding route to that end, I think the EU would be very, very welcoming of Scotland inside the EU itself.
I mean, I would say that's absolutely right. I would say as a former diplomat, the reality is that no other country worth being recognised by would recognise an independent Scotland until London had recognised it. And then there will be a very, very rapid queue of not only EU countries, but other countries beyond European Union. But I can't see any country that we would wish to be recognised by, including all the major, powers, the US and Commonwealth countries and Russia and I can't see any of them jumping that gun until London had recognised an independent Scotland. And for an independent Scotland to be able to exercise its sovereignty, including by joining international organisations or applying to join international organisations by the EU, a constitutional process that was recognised by our present sovereign state, the United Kingdom, would be an essential first step. But with that in place, what I was going to say was, what I do think has changed since 2014 is two things. One, that Charles has mentioned, which is a much more benign attitude to Scotland in the EU because of the approach we took over Brexit. But also the second thing that has changed is, of course, the UK itself would no longer be inside the European Union, and therefore not wishing to tread on the toes of an existing member state would no longer be an issue that played with the rest of the 27.
That's exactly the last point I was going to make, so thanks very much for preempting that. Can I just say one other thing, or ask one other thing, Convener, with your indulgence? It's just that we haven't really touched on security concerns, really, and I know that's obviously Dame Leslie's area of expertise. I'm just wondering what your concerns are going forward in terms of security, where we are in overall security, obviously, but also including things like Europol and the European arrest warrant, etc. So it's not just the kind of military strategic approach, because I understand your former relationship with NATO, but in the kind of law and order area, which obviously is a lot of people are concerned about, given the kind of multinational nature of organised crime.
Convener, I'm conscious this is a huge subject and time is short, so perhaps I'll try and be quite brief on it, if I may. I think there are areas of this portfolio where this Parliament and the Scottish Government actually have serious devolved responsibilities in the criminal justice area, in policing, in jurisprudence, actually, more widely, and in those areas of civil preparedness that are the responsibility of the Government and Parliament. There are other areas where actually Scottish citizens have interests at stake from the wider world context. And the sad thing about Brexit is that it reduces the capabilities not only of the United Kingdom, but also of the European Union and of Western Europe, the whole of Europe more generally. It diminishes the sense of solidarity. It puts in place obstacles to the things you're mentioning, whether it's Europol, the arrest warrant, the Eurojust, the access to databases, and so on. It removes from the EU the substantial body of diplomatic understanding, knowledge, networks, and intelligence understanding and networks, whose assessments in modified form the UK was able to share with European partners. It diminishes the link between EU and NATO, for which the UK was often a linchpin, including in the position of the deputy Supreme Allied Commander in Europe, who was dual-hatted between the EU Military Committee and the NATO Military Committee. So capabilities all round will be diminished, and very sadly at a time when the world is becoming less secure because of growing trade wars between US and China, conflagration in the Middle East, Russia that is more challenging than it was. So it's bad news all round, but there are areas of it that impinge directly on competencies of this Parliament and the Scottish Government, where you have a devolved interest in checking what's happening and being involved in both legislative consent and also in looking at the effectiveness of Scottish institutions and responsibilities in this area.
Thank you very much for that comprehensive answer. Thank you, Kevin.
Thank you. Donald Cameron.
Thank you. I too had some questions on security, some of which you've covered. Can I just ask, firstly, how hard is it to how to disentangle the negotiations over security from sort of wider economic negotiations? Do you see this being something that could be looked at exclusively, or is it just impossible to separate it out?
I mean, there are areas that could be looked at if there was a will, and I don't think there is at present a will on either side. There are some very quick wins. I mean, I think it was it perhaps Stuart Macmillan who asked if were there areas with quick wins. There could be very quick wins in non-security related foreign policy, the general crisis management arrangements, where, frankly, if both sides wanted to, a deal on how the United Kingdom related to the common foreign and security policy would be very, very quick to write down, sort out, and have a pragmatic agreement on. But the further you get into the hard defence issues or the hard security issues, whether they're to do with counter-terrorism and exchanges of intelligence relationship and databases, or whether it's to do with defence, where you get into equipment issues and therefore into commercial issues and therefore into a range of issues that are very closely related to the trade agreements, whether it's to do with quotas or participation or project management or access to financing. You will find it harder and harder to get agreement because the national interests of some very big member states with very big defence interests, commercial interests, come into play. And I can't see the EU wanting to or being able to dissociate the non-commercial, non-defence industry aspects of defence from the other security interests. They've always been bundled, they are linked. There is a link between capabilities in equipment terms and some of the other capabilities to do with training, readiness, operational headquarters and so on, all of which have been political shibboleths inside the United Kingdom, particularly in the Conservative Party, which is now in government. So I can't see any easy way of separating those defence issues. On the internal security issues, whether it's to do with counter-terrorism, organised crime and so on, those could be filleted out. They don't have to be bundled with defence. That would very much depend on whether both sides were willing to, which comes back to what I was saying about sequencing. And I think because they perceive it's where they've got the maximum leverage, the EU side, as we were saying earlier today, will want to start with the issues like fish, like quotas, like services, like trading goods, and not get onto these other areas until they've got established a baseline of the UK's willingness to cooperate in the other areas. So the answer is there's a lot that could be done. In practice, it won't be. Does this mean that we are suddenly exposed to a whole wave of counter-terrorism and so on that we wouldn't have been before? I don't think anybody should be sensationalist about that. The reality is that although police and justice and judicial cooperation will have serious obstacles put in its place, when it comes to hard operational cooperation between security and intelligence services, that will continue to happen rather quietly, bilaterally, and not under an EU umbrella. And if there is an immediate and real threat to the United Kingdom that originates in another member state, I would expect the security and intelligence services to talk to each other very rapidly, the way they always have.
Can I maybe? Sorry.
Go on, you want to go first?
Just to add a couple of short points. One is of course, all this assumes that the negotiations are going well. If we have a breakdown in the main negotiations, then it becomes virtually impossible to agree on anything else. The other point I just wanted to make is that when we are looking at the overall coherence between foreign policy of the UK and the European Union, it's an open question in my mind whether there will still be that level of coherence we have at the moment. When it comes to some of the big critical questions which are now around on the global level, where, for example, the US has a very different view than the European Union, will the UK start to side more often with the US than it does with the EU, for example? When you look at issues around investment screening, or when you're looking at issues around Iran and how you deal with those kind of situations. So I think there's that added complication of the uncertainty in how far the objectives of the UK will still be the same broad objectives of that the EU has at the moment.
I was just going to say that, I mean, without wanting to sort of over-egg this, we shouldn't underestimate the dangers inherent in losing access to the databases. We don't just lose access to the databases, we lose access to any information we've taken out of the databases to date because of EU data protection. And in terms of the fight against terrorism or criminality, that is really very, very significant. We effectively become blind if an agreement isn't reached. And the implications of that, I mean, who knows what they are, but I don't think they're going to be positive in any way, shape or form. And any amount of collaboration with other police or intelligence services across the European Union is, they will not be able to share that information with us if it's out of these EU databases. So it impedes our ability to deal with some of these threats.
Absent an agreement.
Hmm.
Yeah.
Charles.
I do detect, travelling around European capitals, a real shift on this dossier over the last 18 months. In 2018, I was told by senior people in Brussels and member state capitals, particularly in Paris, no third country can have a close relationship with the EU on security post-Brexit, because if it did, there'd be a problem of precedent. If the British have some mechanism allowing them to plug into our machines and apparatuses, then the Turks will ask the same thing, the Americans will, the Moldovans will, and they just have to be kept at arm's length. Well, there was a lot of pushback from member states last year. And when I was in Paris and Berlin in the autumn, and indeed in Brussels, I was told, actually, we want to create bespoke arrangements that we will offer to the British to plug them in very closely in our mutual, to our mutual benefit. And we're not going to offer these bespoke arrangements to other third countries. So there's a lot more pragmatism. And even in the Commission now, I've noticed there's some of that pragmatism creeping in. So I think that for reasons of self-interest, the EU's become more flexible and pragmatic than it was. But of course, the caveat is, on JHA matters, Justice and Home Affairs, the UK will have to accept a substantial role for the Court of Justice, which will be politically difficult, and it'll have to accept EU rules on data privacy, which are difficult. And as Anand rightly said, if the trade talks end in tears, and that's certainly going to mess up the talks on security.
Can I ask, so narrowing down to internal security, what do you believe is the scope for continuing cooperation in terms of sort of judicial cooperation, I suppose, in terms of police and criminal matters, such as the European arrest warrant? Do you see that positively?
I mean, my view is it could be done, but the United Kingdom has to want to do it. And if it doesn't want to do it for wider political reasons, just as there are some things on the economic front it doesn't want to do for wider political reasons, then it won't do it. And if it doesn't do it, and I'm sure ultimately it will do it, but it may be a very long time before it persuades itself to do it. If it doesn't do it, then we have to fall back on the same arrangements as third countries. And that involves a very much longer process of putting in a request for information from other prosecuting authorities or police authorities, putting in requests for extradition and so on. There are channels through which you can do it, but it is very much longer and it's less certain in its outcome, because it will depend on the national law in each state and what standard of evidence they want and whether or not they regard that particular request as judiciable in their jurisdiction and so on. So it will be a much less certain process, a longer one, and one that has different outcomes depending on which member state you're talking about.
Am I right in thinking that Norway has recently signed a surrender, an agreement recently in November last year, in terms of
you may be right. I mean, all of these things are very doable, but you have to want to do them.
Lastly, can I, and you've, Dame Marriott, you've touched on this, some matters of internal security fall plainly within devolved competence. How would you suggest that Scotland's interests in this sphere are best protected, given that this Parliament, for example, has competence over issues like policing and criminal justice?
Well, first of all, speak up, speak often. I have to keep on asserting that because the degree of ignorance about the fact even that Scotland has a different jurisprudence than the rest of the United Kingdom is not well known in Whitehall, which is quite shocking, let alone elsewhere in Europe. So go on speaking up. The legal profession needs to go on speaking up, so do senior police officers and so on, and go on cultivating every conceivable bilateral link with every conceivable other jurisdiction that you possibly can, and then go on through your own political channels persuading Westminster that this is an issue.
Maybe just to add to that, I think what will be important within especially such a short time frame of negotiations is that as much as possible real solutions are being put on the table. So actually working out some of the tricky legal issues which are associated with that and making a concrete proposal which is compatible with European law would take it a long way towards having a better reception on the other side. The European Union in many of these areas will be waiting for the UK to come up with the proposals. So if those come from Scotland or from London, that wouldn't matter very much from an EU perspective. But I think this is also coming back to the broader point about engagement with the European Union. By becoming a third country, and this I would say applies to both the UK as a whole and to Scotland, it's actually a requirement to have much more engagement. You are now going to miss the formal links, you're going to miss the participation in the decision-making processes. So it actually requires a lot more engagement, a lot more being present, and I think it's interesting to look at a country like Norway, which actually has a very heavy investment in Brussels, because the Norwegian government recognizes that as a third country it has to do much, much more to actually get towards solutions which also work for Norway.
And as an aside, of course, we've been talking about security, but this is equally true of things like family law, so issues of child protection, of dual marriages, children crossing borders and so on, where there is Scottish jurisprudence that is different.
Okay, thank you very much. To go back to the issue of getting a deal before the end of the year, the purpose obviously originally of the implementation period was to allow businesses to become ready for what would happen after a deal was achieved. I mean, what's come across clearly today is that there's no certainty around that. We've talked about different deals, thin deals, no deal at all on services. So what advice can you offer to businesses? What should they be preparing for?
Well, I mean, one of the obvious answers to that is if we're right in terms of the kind of deal that's going to be negotiated, then a lot of that no-deal planning will come in very, very useful because you're essentially still planning for a number of checks at borders. But it's worth bearing in mind that there are two overarching sources of uncertainty that businesses have to face. The first is about the nature of our relationship with the European Union going forward. And the second, given that the government wants the right to diverge in terms of regulation, is what the government intends to do here. And we're not very, very clear on either at the moment. So I feel for businesses in the sense that they have those twin sources of anxiety. But the best they can be doing, I suppose, is getting themselves ready for the kinds of checks that appear inevitable now in terms of trade with the European Union.
Thank you. Phoebe.
I think, to put it very bluntly, it's to prepare for the worst case scenario. I think fundamentally the probability, whether it's going to be no deal or a thin deal, but the probability is that whatever is being put in place is very minimal. So from a business perspective, that means, I think, in almost anything but a very chaotic Brexit, but it's the worst case scenario they need to prepare for. What does that mean? I think the reality is it's a question of how quickly you take the consequences as a business, not what the consequences are. The consequence is that essentially the UK will no longer serve as a basis to serve the European market. So if that is the reason why you are in the UK, then you will have to think about how you shift your operations elsewhere.
Thank you. And so do you think that the warnings in Operation Yellowhammer are still relevant?
Yes.
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 Charles.
Oh yes, I also think that businesses should speak out more than they have done. Although it looks like at the moment we all expect a rather hard Brexit, because it looks like at the moment the Tory party, for the first time in its history since the 1830s, doesn't really care what big business thinks. Nevertheless, it is possible that if businesses speak out more boldly and bravely than they've done in the last couple of years, they could shift public opinion and shift Conservative Party opinion. It's not impossible to imagine that the Conservative Party might think at some point, let's not completely kill all the gooses that lay our golden eggs. I mean, at the moment, 5 sectors of manufacturing industry are really heading for a very sharp fall. They are chemicals, pharmaceuticals, aerospace, cars, and food processing. Those 5 sectors, which depend on moving goods rapidly across borders, are really heading for a very difficult period, and I think they need to speak out more. It's not impossible they can shift outcomes by speaking out, but of course, as others have said, they do need to prepare for the worst.
Right, we're on that rather depressing note. I think we'll bring things to a conclusion. Can I thank you all for coming today and sharing your knowledge and expertise with us. It's been extremely useful for the committee's work, so thank you again for coming, and we shall now move into private session. Thanks.